Hello, my name is Susan Dawson-Tibbits. I'm with the law firm of Johnson, Bunce & Noble in Peoria, Illinois, and I'm here today to talk to you about the ABLE Act legislation. ABLE, or A-B-L-E, stands for Achieving a Better Life Experience. Federal legislation was signed by President Obama into law in 2014, and in 2015, Illinois actually established enabling legislation. The federal law is found at 26 U.S.C. Section 529A, and ABLE programs are very similar to prepaid tuition programs that provide a tax break under federal law. As of this taping, 6 states have already launched their ABLE programs. Those are Michigan, Ohio, Tennessee, Florida, Nebraska, and Oregon. And as of yesterday, I received a communication from the Secretary of State's office in Illinois that Illinois would be launching its ABLE program as of January 2017. So what does an ABLE program do? The ABLE program in each state allows a disabled person, known as the beneficiary, to establish a special tax advantage savings account. And the funds in this savings account, as well as the interest on those funds, does not count against that disabled individual in determining their eligibility for SSI or for Medicaid. In Illinois, an ABLE account can accumulate up to the amount of $100,000 per year without affecting a person's individual SSI benefits. If the funds in the account accumulate over $100,000, then the SSI will be suspended but not terminated, so that when the funds in the account go below $100,000, the SSI can be restarted. There is an upper limit to the ABLE account, and that in the state of Illinois is $350,000. So in no situation will any tax advantage accrue if the account is over $350,000. So what is the purpose of having an ABLE account? An ABLE account is a useful addition to our arsenal of estate planning tools on behalf of a disabled beneficiary. We have always used special needs trust to shelter some funds, either funds that the individual has maybe inherited or gotten from a personal injury settlement, so we shelter that in a first-party special needs trust, or we have been able to shelter funds that come from a third party, such as an inheritance that was written into the will as a special needs trust under a third-party special needs trust. But an ABLE account is an adjunct into that. It is never going to replace special needs trusts. For one thing, the maximum amount that can be accumulated in the account is $100,000. At that point, the SSI is suspended but not terminated. If the funds in the ABLE account accrue over $100,000, then any distributions are going to be taxable from that ABLE account. And there is an upper limit of how much can be accumulated in the account as a total, and that is $350,000 in the state of Illinois. So, what can the funds in the ABLE account be used for? The legislation refers to qualified disability expenses, or QDEs. What is a QDE? The legislation spells out such things such as education, housing, transportation, assistive technology and services, personal care services such as a homemaker or housekeeper, or even somebody who provides personal care services, can be used for legal expenses, can be used for funeral and burial expenses. And as long as the funds in the account are distributed for a qualified disability expense, then there is no taxable result to the beneficiary. It is not considered income of the beneficiary, and it can be used for those qualified disability expenses, unlike a special needs account where any money that is distributed from the special needs account but used for food or housing are going to result in a reduction of the SSI benefits. So what are the differences between a special needs trust and a new ABLE account? For one thing, the beneficiary of an ABLE account is the sole owner of that account. And that means that that person has the right to direct the investments that are in that account. Now, for persons under guardianship or where they have signed a power of attorney, that agent under the power of attorney or that guardian can be a designated representative under the law, so that that person who's the guardian or the agent would have a right to assist the beneficiary or even make decisions for the beneficiary. Another difference is that the beneficiary of an ABLE account is restrained to one account, whereas there could be many different special needs trusts on behalf of a single beneficiary of a special needs trust. So Grandma could set one up in her will, Aunt Susan could set one up in her will, brothers and sisters could set them up. They could have 6 or 7 different special needs trusts in a certain situation. But the biggest difference with an ABLE account is that the amounts contributed by any number of people that can contribute to this ABLE account, but the total amount of contributions per year is currently limited to $14,000, and that is tied to the amount of the federal estate gift tax amount that persons can give without a gift tax return being required. So in 2016, that limit was $14,000. That is also tied to the ABLE account, where the total amount of contributions, it could come from 20 different people, but the total amount of contributions cannot exceed $14,000. Now, the one other disadvantage of an ABLE account is that the funds in the ABLE account, especially if they've been contributed by third parties, can be subject to a Medicaid payback, unlike a third-party special needs trust. So that's something to think about, especially if the account grows very large, and depending on when that person dies, there may be a Medicaid payback. But one way around that is that the ABLE legislation does allow the ABLE account to be transferred to, say, a brother, a sister, a half-brother, half-sister, whoever who is also disabled and meets the other criteria. That those funds can be transferred to that new beneficiary in a tax-free exchange. So there's going to be some differences between special needs trust and ABLE accounts, but this is going to be a very valuable tool for assisting our disabled clients in rising out of poverty, where they're no longer confined to just having $2,000 and nothing more, but they are going to be able to have a fund that will pay them to make their life better, for expenses that make their life better. And therefore, an ABLE account is going to be a very useful tool for attorneys who represent disabled clients. And if you'd like to learn more about ABLE accounts, you can check out online my presentation from the April 2016 third annual Elder Law Boot Camp, which you can find on the ISBA Archive CLE Programs section. I also encourage you to join the ISBA Elder Law Section Council. It's a great resource for people who work in this field, and I'm sure that you will find it very useful to your practice.